This is the Italian Citizenship Podcast, hosted by Marco Permunian and Rafael Di Furia.
Hello and welcome to another episode of the Italian Citizenship Podcast, presented by ItaliancitizenshipAssistance.com. Of course, we are back at it again with Italian attorney Marco Permunian, and I am Rafael Di Furia. And in this episode, we wanted to talk about the rules for Italian citizenship for those who have an appointment or court case scheduled that was made before March 28th, 2025. The information in this episode will sound very familiar to those of you who are familiar with our earlier episodes, because the rules for those who were able to make an appointment before March 28th, 2025 will be able to have a guarantee of these rules being applied to them. But Marco, before we started recording this episode, I know you said there was something that you wanted to also discuss regarding the introduction of this topic and how things might look for those who were able to make an appointment after the fact, and how potentially these old rules might be able to apply to them.
Thank you, Rafael. As you said, in this episode, we're going to discuss the old rules, basically the ones that were in effect prior to the Tajani decree. And as you mentioned, those individuals who were able to book an appointment prior to March the 28th, even if their appointment will be after March the 28th and even in the years to come, will be guaranteed the use of these rules, which doesn't mean that those individuals who don't fall in this category will not be able to use these rules. We have mentioned in several of our recent episodes that there are several arguments and several ways to have individuals potentially grandfathered in. And of course, those who were not able to secure an appointment prior to March the 28th with their local Italian consulate can refer to those episodes for more information. But in this episode, we wanted to focus for a minute on the rules that were in effect prior to March the 28th, which are the rules that are guaranteed for those who are able to make an appointment prior to the cutoff date. And it goes without saying that these rules are also applicable to cases that were pending before an Italian court or consulate as of March the 28th. And before we get into the actual rules, I think it's worthwhile mentioning that the Italian Constitutional Court recently rendered a decision which confirmed the old rules as they were. In fact, some courts requested that the Constitutional Court rendered a decision as to whether the so-called old rules were compliant with the Italian Constitution. And very recently, in the month of June of 2025, the Italian Constitutional Court rendered their final decision, stating that the old rules were fully compliant with the Italian Constitution, and therefore they were not to be changed in any way. And of course, we at ICA are in the process of assisting our clients in fighting against the new unjust rules. But of course, in this episode, we're going to be focusing exclusively on the old rules that apply to those who were able to make an appointment prior to March the 28th. With all of that being said, say somebody has booked an appointment in 2024 at the Italian consulate in San Francisco, and the appointment will be in 2029. What are the rules that will apply to the case? First of all, this individual will be able to claim citizenship through an Italian-born ancestor without any generational limits, which means that it's sufficient to be able to qualify for citizenship by descent that an ancestor in the family line was born in Italy and that was still an Italian citizen when their child was born outside of Italy. And again, this ancestor can be a grandparent, great-grandparent, great-great-grandparent. It doesn't matter as long as the individual was born in Italy or was still alive in 1861. It is also important that the Italian-born ancestor didn't naturalize prior to 1912, because if the naturalization of the ancestor occurred prior to 1912, then the transfer of citizenship to their child wasn't possible under the rules that were in effect prior to the 1912 Italian citizenship law. All of this means that it's possible to claim citizenship through an ancestor that wasn't even born in Italy, meaning an ancestor who was born in the Italian territory prior to Italy becoming a nation, as long as the person was alive in 1861 when Italy was unified, and as long as this person naturalized later in life after 1912. By naturalized, we mean the acquisition of a citizenship in a foreign country, usually the country in which the person was relocating, by a voluntary act put in place by the immigrant. In the US, for example, that was a multi-step process. It began with a declaration of intention, a document with which the person would declare their intention to become a citizen of the United States, followed by a petition for naturalization, which was a formal official request to become a US citizen, and all of the requirements were met, then the person would have been granted US citizenship formally and would receive a certificate of naturalization. Of course, this is one of the key documents that need to be obtained and translated in order to prove when exactly the Italian-born ancestor received Italian citizenship. Other documents that are required are birth certificates, marriage certificates, and death certificates for all of the individuals in the Italian line, from the Italian-born ancestor all the way down to the applicant. Some consulates will also require that the applicant provides documents pertaining to the spouses of the individuals who are in the Italian line. For instance, if you're claiming citizenship through your great-grandfather, besides his birth certificate and his death certificates, you will also need to provide his wife's birth certificate and death certificates. Of course, also their marriage record is a document that is required. All of the vital records that originate from the US also need to be apostilled, and the apostille is a certification that needs to be obtained from the Secretary of State of the state in which the document originated. The Italian vital records, for instance, the birth or marriage certificates of your Italian-born ancestors, as well as their naturalization records, do not need to be apostilled. And of course, all of the documents that are in English need to be translated into Italian. Now, of course, these are quite general requirements, which means that some specific consulates in the US or around the world might have more peculiar and slightly different requirements that are applicable to applications that are submitted through that specific consulate. So it's always best to consult the website of the consulate where the application will be filed to understand if there are more specific requirements that will apply to your case.
Well, Marco, thank you so much for getting into this so far. But just before we continue on, when we're talking about the legalizations and document gathering, I know that there are many individuals who have to deal with discrepancies of maybe names or dates or different details on the documents that they'll be presenting. Can you tell us a little bit more about how a person will actually have to deal with those? Do they have to correct them? Are there ways to amend them? What are the steps that a person would need to take to make sure that everything is ready to go?
It is very common for vital record documents, especially the older ones, to include incorrect information or misspelled names. That has to do, of course, with the fact that individuals who reported their own information or other people's information oftentimes were not able to read or speak properly. But I think a distinction needs to be made between major discrepancies and minor discrepancies. Major discrepancies are those involving unofficial name changes, for example, meaning when the person unofficially went from a name or last name to a completely different name or last name. And in those cases, very complex amendments may be necessary in order to have vital records with correct information. In some cases, court orders might be necessary to amend documents because the offices of vital statistics will not be able to amend, in some cases, discrepancies that are too big, and therefore they might request an official ruling from a court to proceed with the amendment. In some cases, it will be so hard to amend every single document that a one and the same court order might be necessary to resolve the situation, meaning that you might have so many documents with conflicting information that you might just need a judge in the US to assess all the documents and issue a ruling which indicates that despite all of the discrepancies, all of the documents pertain to one individual or these specific individuals that are in your family line. And when a one and the same court order is obtained, generally speaking, the Italian consulate is satisfied with whatever a US court establishes. With that being said, minor discrepancies are those, for example, that involve a wrong letter in a last name. Maybe one letter is off from the last name, or the first name was just slightly changed, or maybe the person adopted the English version of their name. Maybe they went from Antonio to Anthony. And also, for instance, when the date of birth is off by 1 day, that could also be considered a minor discrepancy. And in these cases, of course, it's up to the applicant and their lawyer to decide whether to spend time and resources in amending these documents or go with the documents as they are. And of course, it's up to the discretion of the consulate whether these discrepancies can affect the outcome of the application. So of course, whenever possible, it's always advisable to amend all the possible discrepancies in the application. But of course, in some cases, that is not realistic. So we at ICA can advise our clients on whether amending certain discrepancies will be absolutely necessary based on our experience with that specific Italian consulate.
Well, that's great, Marco. And just something that you mentioned earlier about translations, that the documents will have to be translated. Could you tell us a little bit more about how those documents will have to be translated, if they have to be in a certain format, if a certain special type of translator has to be used, and in what situations that might come up?
Generally speaking, Italian consulates require professional translations, which means that they don't need to be certified, but it's not advisable for somebody who is not extremely fluent in Italian or a native speaker to do their own translations, because whenever the consulate receives incorrect translations, they will normally send them back or raise problems or ask the applicant to redo them. So it's absolutely necessary, in my opinion, to rely on the services of somebody who is extremely fluent in Italian or who is a professional translator who is a native speaker. With that being said, some consulates will require certified translations, which means that the translator who has done the translation will need to appear before a public notary to swear that the translations are faithful and accurate. And that normally applies to legal documents, which means that, for example, divorce decrees or name change decrees will need to be translated this way. Of course, like I mentioned before, every consulate has different requirements. So if you are unsure as to whether your translations will need to be certified or not, it's best to consult the website. It's best to visit the website of your local Italian consulate to better understand the requirements regarding the translations.
Well, Marco, thank you so much for getting into this topic. Of course, this has just been a quick overview of the general rules for Italian citizenship by descent as they applied to individuals that have scheduled their appointments before March 28th, 2025. But just before we finish off this episode, would you mind just giving us one more quick rundown of who are the individuals who are guaranteed to have these rules apply to them?
Individuals who have booked their appointment with an Italian consulate prior to March the 28th, even if the appointment will take place after March the 28th. Individuals who have booked their appointment to apply for citizenship with an Italian municipality, even if the appointment with the municipality and the clerks in Italy will take place after March the 28th. And finally, individuals who submitted their cases to an Italian court prior to March the 28th.
Well, thank you again so much, Marco, for making yourself available for this episode of the Italian Citizenship Podcast. But for those who may be interested in applying for citizenship through ancestry, marriage, or residency, how can they get in contact with you and your team?
People can contact us through our website, italiancitizenshipassistance.com.
Well, absolutely fantastic. And of course, for those of you who are interested in more information like this, be sure that you're subscribed to this YouTube channel, as well as the audio-only podcast. But of course, if you're subscribed to this YouTube channel, that means that you are also automatically subscribed to episodes of the Italian Real Estate Podcast, as well as Ask the Italian Lawyer, where we get into the logistics and realities of making your life in Italy. Of course, for more about life abroad as a dual citizen expat, be sure to come over to my YouTube channel, youtube.com/Rafael Di Furia, or you can search for Not Your Average Globetrotter. But again, we have been here with Italian attorney Marco Permunian from Italiancitizenshipassistance.com. I'm Rafael Di Furia. Stay safe and healthy out there, and we will see you all next time. Thank you.
Thank you.